What does estate planning mean? What does it mean to get your estate plan together? Hi, I'm Dan Covington. I'm an estate planning attorney in Lawrence, Kansas. I've been doing this for over 20 years, helping people secure their assets and get them where they want. So what does estate planning mean? What's it all about? What are the basics of a good estate plan? So first, let's talk about a trust. What does a trust do? We've all heard a little bit about them. It can probably mean a lot of things to a lot of people, but essentially a trust provides a place for you to put your assets for yourself during your life and during your incapacity, and then once you want to pass them on. Obviously, a trust ultimately distributes those assets after your life, suppose there's you and a spouse, so after the life of both of you to your ultimate beneficiaries, and those assets are available all during your life. It's that you don't lose control of them because they're owned by your trust, because you're the trustee and the settlor of your trust. A big bonus, and you surely heard this, the great thing a trust does so well is it passes along assets to your family, to whatever beneficiaries you name, without the need of probate. This means you have a trust, so what you don't have is a regular will. With a last will and testament, someone needs to file that will with the court, publish it, await deadlines, timelines to run, pay creditor claims, and then distribute assets with the blessing of the court. With a trust, you need not mess with most of that process. It makes things much easier on families. You can rest assured that things are set up and taken care of. So when your time comes, there's not one additional hassle. Also, a trust can provide. This is maybe a little known piece, but a trust can provide for administration over a course of time after you pass away. This is just to say that distributions can be stretched out over time. Things can be paid out over 3, 5, 10 years. Distributions can be made upon the occurrence of certain events, or just awaiting. Maybe one of your children gets a quarter of what their distribution will be at age 24. Maybe they get the rest at age 26, 28, or 30. But this is maybe the other half of the real beauty of a trust, is that you can determine under what conditions, by writing a provision into your trust, you can determine under what conditions distributions will be made. And that's a lot of time what people are after. I've with some clients heard this called the Camaro problem, right? You don't want you don't want to pass on everything divided among your children as soon as you pass away. Let's say your children are not of a very mature age yet, and they say, wow, I've got all this cash in the bank, I'm going to go buy a depreciating asset. Well, that's fun for them, but that's maybe not the highest and best use you intended for your funds. So your trust can allow funds to be, sometimes we use the word trickled out, that funds can be paid out over time. And again, this is a provision you write into a trust. Your trustee's bound by that distribution schedule. What else? Another good piece of a good estate plan is a durable power of attorney. You've heard of this document a little bit. It doesn't get the press that a trust does, that a will might get. But a durable power of attorney is really just a document wherein you authorize someone to act on your behalf during your life only. It expires automatically at death, but during your life, you've authorized someone to act on your behalf for business and finance and healthcare decisions. So he or she can never act. This person, by the way, is called your attorney in fact. It need not be an attorney. It's usually not an attorney, but the person you name is called your attorney in fact. And due to this document, they can act on your behalf, but not against your competent wishes. But this document really can be very helpful anytime, again, during your life. It can be helpful during your absence. They can act during your incapacity. And that's a big one, right? If later in life, let's say you came to a point where you began suffering from some memory loss, some dementia, some Alzheimer's. At that point, you likely no longer have capacity maybe to appoint someone, to name someone as your attorney-in-fact in a durable power of attorney. So you need to have had one of those documents ahead of that, because now someone can act on your behalf. They can help you take care of your business. They can help you with medical decisions, medical arrangements, medical finances. And if you have this document, you should be in great shape. If you don't have this document, however, in Kansas, that person is going to need to go be appointed as what's called a guardian and a conservator for you. So this means they need to go to court. Even if it's your spouse, they don't have any special power to act or to sign on your behalf. So they need to go to court. They need to file a verified petition seeking to be appointed as the guardian. That's someone who cares for your person. And as a conservator, that's someone who cares for your assets, your finances, your business interests. They go to court. They ask to be appointed. They send notice to close family. The court has to determine that you are an adult with an impairment, someone in need of help, essentially. And then if the court determines you're the right person for the job and that you don't have a conflict, then you may be appointed simply to take care of your spouse during their life. It's really, it can be necessary, right? I'm not saying that the due process isn't necessary, but it's not necessary if you already had a durable power of attorney, a document in place that takes care of all those things. And at the very least, your attorney-in-fact you're out of state on whatever kind of trip. Your attorney-in-fact can sign something on your behalf, can take care of little things. You can be there, you can be absent, you can be across the street, out of state, out of the country. They can take care of a lot of things for you. Finally, maybe another piece of an estate plan that you've not heard of. This is called the pour-over will. A pour-over will is really a pretty minor document. It can be important once in a great while, but a pour-over will just says, I have this trust. It's my genuine estate plan. It's where I've said what I really want to happen with my assets. But in the event I forgot or neglected to put a major asset into my trust, this pour-over will is just to push that asset or those assets into my trust. Again, it just says my trust is my real estate plan, and I have this pour-over will. It doesn't have a lot of details in it. It just says I want anything that I left out, please put it in my trust. Also, there's a document called a living will, an advance directive. You may have heard of these. This is a document that expresses your wishes. You hear people talk about, I don't want to be kept alive by machines. That's the gist of it. A living will is a statement of intent. It's not a contract that binds anyone, but it tells others, including your attorney-in-fact, someone who can act on your behalf. It tells others that you don't wish to be maintained by life support machines if you do not really have a prognosis of recovery to your quality of life. Of course, you want to look at a document like that closely. You want to know that it aligns with your intent before you sign it. But it is a way you can let people know if these are your wishes. It can take a burden off of your attorney-in-fact, off of your family, that they know those wishes and they don't have to guess. So we've talked about the basics of a trust, durable power of attorney, a pour-over will, and a living will or advance directive. Hopefully this clarifies a lot of things for you. I realize it was a broad sweep over a lot of these topics, but hopefully it clarifies for you and empowers you to make a better decision as a consumer of legal services. Again, I'm Dan Covington. You can always find me at Estate Plan Kansas, and I'd love to help you with your estate plan.